International peace law, the introductions to international law and peace, the definitions of peace, challenges and trends, structural approaches to peace, the role of international institutions, civil society and peace, the legal framework, and the historical peace treaties. The United Nations Secretary General Antonio Guterres once remarked, "We are a world in pieces. We need to be at world. We need to be a world at peace." This statement underscores the elusive nature of peace, a concept that varies across historical epochs, cultures, institutions, and academic disciplines. In international law, peace remains particularly ambiguous. Hirsch Lauterpacht, a prominent scholar, asserted post-World War II that international law should aim to establish peace between nations and protect fundamental human rights. While human rights protections has become a primary goal of international law, the promotion of peace as public good has largely been neglected. This neglect is partly due to the dominance of positivist legal approaches and the fragmentations of international law into technical subfields like trade law, the IHL, which often overlook broader values such as peace. It suggests that recognizing peace as a common function of international institutions could enhance interactions between different legal fields, reducing fragmentations. Additionally, there is a trend towards normalizing violence within international law, which undermines non-violent dispute resolutions mechanisms. There are two types of peace. The first is negative peace. This refers to the absence of war or armed conflict. Historically, this concept can be traced back to Hugo Grotius' distinctions between the law of war and the law of peace. Negative peace focuses on preventing armed conflict through non-violence, dispute resolutions, and condemning the unlawful use of force. While positive peace is a broader concept, involves the presence of cooperations between people and states, social justice, respect for human rights, and eliminations of structural violence. The structural violence includes poverty, inequality, and exclusion caused by inequitable resource distributions and denial of equal protections. Negative peace, against it refers to the absence of war or armed conflict. Positive peace is the presence of cooperations between people, states, social justice, respect for human rights, and the eliminations of structural violence. The United Nations Charter is crucial to modern international peace law, emphasizing international peace and security. Key articles include Article 1, outlines the purposes of the United Nations, including maintaining international peace and security. Article 2.3 mandates peaceful settlement of international disputes. Article 2.4 prohibits the threat or use of force against the territorial integrity or political independence of any state. While Article 2.7 prohibits United Nations interventions in domestic affairs, with exceptions for enforcement measures under Chapter 7. The United Nations Charter focuses on maintaining peace, fostering friendly international relations, and promoting cooperations to solve global issues. The United Nations Charter includes key articles such as Article 1, Article 2.3, 2.4, and 2.7. The war on terror has led to more Chapter 7 enforcement, including sanctions and counter-terrorist actions, raising human rights issues. The responsibility to protect R2P has evolved, allowing humanitarian interventions under certain conditions, though it remains legally controversial. Human rights violations are significant risk factors for breaches of peace. The doctrine of structural violence highlights how social structures and institutions can threaten basic human needs and rights, contributing to conflict. Sustainable development and environmental protections are also crucial for achieving long term peace. International law contributes to peace through investment law, environmental protections, and nuclear disarmament. Investment law offers peaceful dispute remedies and aids post conflict reconstructions. Environmental law ensures human security and peace. Disarmament efforts are key to maintaining peace. Civil society, including women, refugees, and ethnic minorities, is vital for peace building. Their participation in peace processes is essential for achieving sustainable peace. The relationships between peace and justice is complex and it is intricate. Transitional justice mechanisms such as truth commissions and international court aim to address past human rights violations and promote reconciliation. However, these mechanisms face challenges such as legitimacy issues and the risk of polarizing post conflict societies. International law promotes peace through a holistic approach. It integrates various legal fields and addressing both negative and positive aspects of peace. Further research is needed to explore connections between peace, security, development, and human rights, and to develop effective strategies for achieving sustainable peace. The international legal framework for peace is built upon several foundational instruments. Each of them contributes to the modern understanding of peace under international law. These instruments form a complex yet interconnected web of legal obligations and principles. The United Nations Charter, as mentioned earlier, key purposes include to maintain peace, to develop friendly relations, and to achieve international cooperations. In Nicaragua versus United States in 1986, the International Court of Justice highlighted the importance of Article 1 of maintaining international peace and security, condemning the use of force by United States in Nicaragua as violations of international law. In Agency Continental Shelf between Greece versus Turkey, 1978, the ICJ emphasized the obligations of state. The ICJ emphasized the obligations of state to settle disputes peacefully, as outlined in Article 2.3, urging Greece and Turkey to resolve their differences through negotiations and other peaceful means. In Corfu Channel case, United Kingdom versus Albania, 1949, the ICJ ruled that Albania's actions in the Corfu Channel violated Article 2.4 by using force against British warships, reinforcing the prohibitions on the use of force. Chapter 7 outlines the United Nations Security Council's powers to maintain peace, including Articles 39 to 51. It allows the Council to determine threats and take actions to restore peace. Some of the cases, such as Libya versus United States and Bosnia and Herzegovina versus Serbia, Article 7 provides for enforcement measures. Libya versus United States and United Kingdom, 1992. The ICJ dealt with the legality of Security Council resolutions imposing sanctions on Libya under Chapter 7, affirming the Council's authority to take enforcement measures to maintain international peace. While in Bosnia-Herzegovina versus Serbia, Montenegro, 2007, the ICJ recognized the Security Council's role under Chapter 7 in authorizing measures to prevent and respond to acts of aggressions and breaches of peace. The Bryan-Kellogg Pact, 1928, a landmark treaty that explicitly renounced war as an instrument of national policy. The Hague Conventions, 1899 and 1907, establishing the framework for peaceful dispute resolutions and the Permanent Court of Arbitrations. The Rome Statute of International Criminal Courts, some of the modern legal instruments, the Arms Trade Treaty, the Conventions on Eliminations of All Forms of Discriminations Against Women, and also the Security Council Resolutions 1325 on women, peace, and security. The case of Nicaragua versus United States, particularly noteworthy. In these decisions, In their decisions, ICJ confirmed that the prohibitions on the use of force, as codified in Article 2.4 of the United Nations Charter, constitutes a jus cogens norm, which means a fundamental principle of international law from which no derogations is permitted. The modern legal framework recognizes two interconnected concepts of peace: negative peace, which focuses on absence of direct violence and conflict preventions, and positive peace, which addresses the root causes of conflict and promotes social justice, human rights, and sustainable development. Some of the various preventive measures in international relations include diplomatic channels, arbitrations, mediations, early warning systems, enforcement mechanisms, United Nations Security Council resolutions, international sanctions, peacekeeping operations, and international criminal justice. Some of the challenges in peace building um, including institutional fragmentations, implementation gaps, emerging issues like cyber warfare, non-state actors, environmental security, and gender dimensions. Some of the key areas of legal integrations and reform: enhanced integrations focuses on better coordinations and stronger links between legal regimes. Institutional reform aims at strengthening mechanisms and creating new frameworks. The international law of peace is dynamic legal framework. Understanding its various components is crucial. The framework continues to develop in response to new challenges and changes in global circumstances. Um, International peace in international law is not merely the absence of conflict, but also encompasses a broader spectrum of legal obligations and principles. The future development of this area of law will require continued attentions to both traditional and emerging challenges in pursuit of global peace and security. As mentioned earlier, peace is elusive concept with varying definitions and valuations across different historical, culture, institutions, civil society groups, and academic disciplines.